Imagine waking up one day to discover that someone, somewhere, had registered a phone number in your name, linked to your Ghana card, and you knew absolutely nothing about it. These precise facts led to litigation in the Ghanaian courts that traveled all the way to the Supreme Court. The court has provided some very important legal nuggets on privacy law. All courts follow the Supreme Court on points of law, so when the Supreme Court speaks, we must pay attention. In May 2023, in the aftermath of Ghana's national SIM registration exercise, Elom noticed that an unfamiliar Vodafone Ghana number had been registered in his name. His Ghana card was linked to it, and it even had a Vodafone cash account, all bearing his identity. He had not authorized it and was completely unaware about it, but he was concerned because everything that number did would lead right back to him. He sued Vodafone Ghana and the Attorney General at the High Court for compensation and a log of all the activities that the number had undertaken. Vodafone's defense was that any use of Elom's data was with his consent and that their registration process had two phases. First, linking a Ghana card, and second, capturing biometrics. The argument was simple, that without a Ghana card, phase 1 could simply not happen, so by implication, Elom did it himself, or someone he knew had done so. They even pointed out that Elom had another Vodafone number, which had no complaints, so they suggested that he was fine with registering numbers. The Supreme Court had two words for that kind of reasoning. It was puzzling and strange, because Elom's complaint was on one number, not the other. That was the entire point. Concerning the Vodafone cash account, Vodafone said that those accounts are automatically created after phase 1, but are deactivated and are only activated after phase 2. So technically, Elom lost nothing and suffered no damage. And then Vodafone shifted some responsibility to the NCA, the National Communications Authority, saying that they owned and managed the SIM registration database. Vodafone was merely assisting in data collection. So if anything went wrong with the database, that was NCA's problem, not theirs. And then came the Attorney General arguing on behalf of the Republic. They stated that NCA had to join the action, and the court agreed. And then they argued that the SIM registration process could only begin the moment someone presented a Ghana card. The suggestion was clear, that Elom himself or somebody else had had access to the Ghana card. The implication pointed right at Elom. In any case, the state noted that Vodafone had corrected the error within 3 weeks. So what exactly was the problem? The NCA became the third defendant and they told the court that Elom was simply too hasty. There was a consumer resolution process in-house designed exactly to resolve these kind of complaints. And so Elom should have gone there and exhausted that process before he came to court. By going straight to court, he had jumped the queue. Furthermore, NCA said that they were very well aware that some unscrupulous individuals will attempt to game the system. That is precisely why they had two phases, and the second phase had biometric capture, and that was the safeguard. Indeed, they argued that the systems that they had been designed with all these risks in mind. In summary, all the three defendants pointed liability straight back at Elom or other people. Meanwhile, Elom's identity had actually been used and then quietly delinked 3 weeks later, as if nothing had happened. The High Court sided with the NCA. The case was dismissed as premature. Elom was directed to go through the internal process first. He appealed. The Court of Appeal corrected the High Court and actually heard the case on its merits. It was wrong to make Elom wait on an internal mechanism while his rights hang in the balance. But on the merits, the case itself was still dismissed. The court ruled that Elom simply did not have enough evidence to prove that his rights were violated. Elom then appealed finally to the Supreme Court. The Supreme Court looked at the record and saw that the lower courts had missed out something. Yes, Elom's evidence was thin, but it was simply not his fault. Vodafone and the NCA had exclusive control of all the data, the registration logs, the transaction records, everything that could prove exactly what happened and who did what. Elom had access to nothing. So why would you blame a man for not producing evidence that only his opponent holds? The court also dismantled Vodafone's claim that their system was foolproof, because in the same breath, they had admitted that their own agents had been selling pre-registered SIM cards for commercial gain. Their own people were acting very improperly. Vodafone and the NCA had announced that they would disconnect incomplete registrations by March 2023, but they only released a verification shortcode in May. Yet, that mysterious number on Elom's account was already removed before a deadline. Therefore, somebody knew it wasn't supposed to be there and removed it. Under the Data Protection Act and the Constitution of Ghana, both Vodafone and NCA had a legal duty, the highest standard of duty, to protect people's personal data. They were supposed to design a system that accounted for certain rogue agents, human error, and the possibility of misuse, and they failed. And when confronted with that failure, they pointed their fingers at each other and at the very man whose rights they had violated. The court declared that Elohim's rights had indeed been violated. Vodafone was slapped with 20,000 cedis in damages and costs. It was only a token amount, as the court deemed the case to be driven largely by public interest. What do we take from this story? First, no company, government agency, or body has the right to use your personal information without your knowledge and consent. They are under a duty to ensure that appropriate safeguards are put in place to ensure that information is kept confidential. If they breach it, they may be held liable. Second, when the data needed to prove a violation lies exclusively with the very party accused, that party cannot turn around and blame the complainant for lack of evidence, because justice cannot be held hostage by information imbalance. So even if you have a small piece of evidence and it points to a systemic flaw, that may just be enough to tilt the scale in your favor. Follow Superlaw Jade Studios for more real stories, real cases, real people.